Welcome to the 10th episode of ArbChat. My name is Sunita Advani, and today we have a very special guest with us. She is none other than pre-eminent barrister and arbitrator, Ms Sian Mirchandani KC of 4 New Square Chambers in London. Sian is a highly successful and popular silk working across a wide spectrum of commercial practice, both domestically and internationally. Known for her experience in litigation, arbitration, and adjudication, Sian's practice encompasses construction, engineering, professional liability, insurance disputes, and disciplinary claims. Sian is highly recommended by peers as a really impressive silk who is in complete control of the material. Her ability to maintain the confidence and trust of the court is further applauded. Always very well prepared and completely on top of the facts, clients value her ability to handle high-value, complex, multi-party claims and group litigation involving difficult, detailed quantum issues. She has a particular interest in disputes involving IT, technical, and scientific elements, where her scientific background gives her a considerable advantage. Sian is recognized as a leading silk by the legal directories in construction, property damage, professional negligence, including professional negligence involving technology and construction professionals and issues, and professional discipline. Qualified as a Tech Bar accredited adjudicator, she is also a fellow of the Chartered Institute of Arbitrators. Sian qualified and practiced as a veterinary surgeon before joining the bar. Thank you, Sian, for taking the time out of your very busy schedule to join us today. Before we begin, I wanted to let our audience know that we will have an audience Q&A round at the end of the interview. So if anyone in the audience has a question for Sian, please submit it via the Q&A function on Zoom. I'd now like to start with the first question, which is, which book has had a significant impact on your life or the way you think about the world?
Oh, well, a fantastic question. And the answer really is there are so many books that I would put under that category. I think professionally, it has been Jackson and Powell on professional negligence, which is my Chambers text, because it is pretty much the Bible that I refer to. Personally, in terms of in my life outside work, books like, I recall very much reading Remembrance of Things Past by Proust. And what it made me think about was one's perspective of everything is really unique. And many people can see the same things and not see it the same way. And another absolute favorite is Wind in the Willows. And I always liked the way that Mole was saying, oh, hang spring cleaning. You know, sometimes when you're studying and working away, you just think, oh, I've had enough of this. I'm going to have a break. And that's exactly what he did. And it also reminds me of temptations. The temptations of Toad quite often occur, and one can get distracted by them.
That's really fascinating. Thank you. Next question is, what is the best piece of advice that anyone has ever given you?
Oh, I thought about this when you asked me about these questions, and one came to mind immediately, which really struck me as actually very helpful. A much more senior than me barrister said, the bad days are part of the job too. And I just thought, it's perfect. It's exactly what you need to know, that, you know, there will be days when things go wonderfully. There will be days when things go badly. And it's part of a professional's job to just pick yourself up the next day and get on with it. It doesn't matter. It's called practice for a reason.
Yeah, that's very, very insightful indeed. I'd now like to turn to the topic of your previous career as a veterinary surgeon. Before joining the bar, you read veterinary medicine at Cambridge and practiced as a veterinary surgeon. How have your previous experiences as a veterinary surgeon influenced your approach, if any, to resolving disputes as a leading silk specializing in construction?
I think there are two main aspects in which it's really helped me. One is working from first principles to the point where you understand. And that was very much necessary in my training. You couldn't possibly know all the answers in so many animals. And it's the same when you come to legal cases, particularly technical stuff. So it leads on to trusting what I think, which is if somebody is saying something and it doesn't make sense, then I don't assume that it's me who has got it wrong or doesn't understand. I would question them to explain to me what it is they're saying. And this is particularly important with experts, because some experts will make a statement and then not really wish to clarify what they mean. And I often think, well, if you can't explain it to me, how are you going to explain it in court or in the arbitration hearing to the tribunal? You're talking to somebody who perhaps has not read as many papers as I have, and certainly won't spend as many hours in prep as I have. And if you're not making me understand, we really have to go back and build what you're saying up from the first principles. And that leads on to the second one, which is don't sit around in conferences or whatever, not understanding, just ask. And from a very junior time, I would ask in a conference something if I didn't understand it. And almost never was it the case that nobody was immediately writing down the answer when I'd ask somebody, what do you mean? You know, it was clear that the misunderstanding or the lack of understanding was not just mine. But quite often people are unwilling to speak up and to appear as though they are perhaps less intelligent than the other people around the table. It's not the case. I tend to think now of every stage of a case, I'm here to gather information because I will need it at the next stage. So if I miss this opportunity, I'm going to struggle at the next stage. And if you have that approach, which is very much like a vet has, I have to gather information, then you tend not to end up in a position right at the end where you don't understand the case.
Yeah, that's really good advice in terms of being courageous and asking questions and starting from first principles.
Yes, exactly. I mean, that willingness to interrogate it's instinctive, but perhaps we tend to hand back, or I think women perhaps tend to hand back on the questions.
Yeah, but it's really encouraging for us to see that, you know, that's something that can be developed.
Absolutely. I think I used to call it when I was a vet, it's the boot of the car, the trunk test. I.e., if you arrive on a farm or whatever and you're about to ask a vet about what's happening or ask the owner about what's happening, and you have to get out from the car to go around to the trunk or the boot to find what you're going to have to take with you. In order to know what you have to take with you, you have to have asked questions. And those questions are directed at you finding out what you need. And it's that kind of, what do I need to know for the next stage? What do I need next? So if you're drafting something, what do I need for the introduction, for the section, for the terms? What do I need?
Yeah, that makes sense. And that's really good to bear in mind. So my next question is about female advocates. What challenges have you observed for women in relation to advocacy in international arbitration? And how would you recommend that junior female lawyers address and overcome these?
I think one of the things that I've noticed, perhaps more in arbitration world, not just in hearings, but in the general world and the market of arbitration, and perhaps more so than in court proceedings, is the risk of being drowned out by men who simply speak loudly and keep speaking and fill gaps in conversations so that if you're polite, you never actually get to speak up because it would be interrupting. And I would say addressing that is, it's very much a case of learning with yourself what you're comfortable with as your break-in point. So if you don't know the name of the person and you don't particularly want to start out with, well, I don't know really, but perhaps, then you're not going to get very far. So perhaps being confident with your intro into how you're going to break into the discussion. That's correct, but only to a point, and then you lead on. Or that's wrong for this reason. It's that kind of, rather than putting it back on yourself, indicate that you've listened, but now it's time for them to stop talking because you have a point to make. And what tends to happen, it might not be easy on the first occasion, but what tends to happen is people get used to that being your way of dealing with intercourse and discussions. And so they respond to it. And I do find that if you become somebody who is willing to break into a conversation perfectly politely, but forcefully, they stop doing it to you. They learn that they're going to be curtailed, and they stop trailing on in that way.
That's really wonderful advice. Thank you for sharing that. My next question is, could you provide some practical advice or strategies for junior female lawyers looking to boost their confidence in arbitration proceedings?
I think it is, remember that when you're speaking in a hearing, time is precious, so you need to make your point. And making your point means starting with it. And I think what tends to happen, particularly when you're junior, is that you assume a preamble, an introduction, some of the facts are necessary, whereas actually perhaps turn it the other way around. And I used to do this when I was drafting. Quite often I would draft a point in a paragraph and I'd get to the end and my final sentence would be a great summing it up sentence, but actually it ought to be in the first sentence. So it's that approach. Nail it with the first sentence that you're going to say and then explain is a much more powerful strategy. I think it really lends itself to advocacy in almost any forum. But I think for women, it's particularly important because, again, they build a reputation and an expectation that you are succinct to the point. You nail the point, you explain it. You nail the point, you explain it. Rather than explain, detail, drifting off, and the tribunal are no longer listening. And I think really, in terms of strategies, it's whatever works for you. You can make things seem less significant by, in your head, just thinking it's just a hearing. Nobody's life depends upon it. What I say is not going to be the case of the sky falling down on my head, if that works for you. Or you can use projection techniques whereby you turn what you think of as scary people into mice in your head. And so you're educating them about something. Power stances, throwing your shoulders back perfectly straight, standing tall, making sure that you feel completely yourself when you come to advocate, and breathe. It's actually really necessary to have in-breaths that are perhaps audible, particularly if there are microphones. It doesn't matter. You just proceed that way. And when you're speaking, just a bit like writing, keep sentences a bit shorter, break them up, move on to the next point, give them structure. Say you're going to make 3 points if you have 3 points to make. It helps to give all these signposts to the audience, and the audience is obviously an important one if it's the tribunal.
Yeah, that is really excellent and advice, and I think all of us are going to bear that in mind going forward in our written and oral advocacy. So my next question is, are there any specific initiatives or best practices that you believe have been successful in promoting gender diversity in arbitrator appointments? And as a follow-up to that, what further efforts can be taken by both rising female arbitrators and the relevant stakeholders, like arbitral institutions, clients, and law firms, to increase gender diversity in arbitrator appointments?
Well, I used to think adding a woman's name to the list was a start. But I have actually now come round to thinking rather more along the lines of putting forward an all-female list would be the necessary step. Adopting that much quoted statement by Ruth Bader Ginsburg, which is that the Supreme Court has been male for hundreds of years. I will be satisfied when it's 100% female. And it completely reset my perspective, because of course she's absolutely right. Why would I accept just 50-50? For there to be a rebalance, there will need to be more than that. And certainly in terms of arbitration, and particularly I'm thinking about the Arbitration Act. It's been around for about 30 years, and it's been about 30 years of male dominance. Well, it's not really inequality if you now take such steps as to make the representation of gender representation equal in a short time and not let it take 30 years. So I think that is probably going to be the best practice that will actually change things. I'm not going to pretend that I know exactly all the initiatives that various bodies are taking on. A number of bodies have women on their committees and in their courts. There are rising appointments of women arbitrators, but I still come across senior people in the arbitration world who think adding one woman's name to a list is a significant step, and I just no longer agree. I don't think that's enough of a step anymore. And I mean, I've been in this world for 26 odd years in practicing law. I certainly don't want at the end of my career for there to be any need for these kind of conversations, and that would be the case if we don't make some fairly drastic changes.
That makes perfect sense, and I definitely agree that all-female tribunals are a really good step and a necessary step forward. That actually follows on to my next question about all-female tribunals, and you've sort of already touched on this earlier. So as you know, all-female tribunals are currently relatively uncommon, and some women like you and me argue that all-female tribunals are necessary in light of historically prevalent all-male tribunals, whereas other women advocate for at least one male arbitrator alongside two female arbitrators to ensure gender diversity for men. So what are your views on this debate, in addition to what you've mentioned earlier?
As I say, I went through a complete sea change on this, because prior to thinking about it in the way that Ruth Bader Ginsburg made me see, I was thinking, well, in order for there to be gender diversity, there has to be both male and female on the panels. I'm leaving aside any question of issues over identity of a gender. But the position I now take is that we have got so used to it being all male, one wouldn't even blink if you heard that it was a panel. I regularly appear at conferences where I am the only female. That is changing, but it is still a commonplace thing to happen. And the only way, if it's going to happen, perhaps within my career's lifetime, is for there to be that change. And I'm not saying that it's now going to be like that and like that forever and ever, amen. I'm just saying that in order to get some kind of rebalance, there needs to be perhaps that step.
Yeah, that makes sense as well. And I guess as just a quick follow-up to that, do you also think that the progression of a male arbitrator's career is not necessarily impacted by, having all-female tribunals?
I would say it's not at all. I mean, I would say that women who are in a position to select another arbitrator are only because of this gender imbalance looking at promoting other female arbitrators, perhaps above other male arbitrators. But the market is big, and there is no shortage of slots for male arbitrators. So I don't see that it's a problem in any sense for male arbitrators and their future careers. And in some ways, it almost makes me smile as to think, now you're actually understanding what women in this career have been carrying for decades. You're finally getting a glimpse, and perhaps that's something that male arbitrators should reflect upon, because they have had the position of dominance and numbers for decades.
That's just very insightful and just very deep. And I think like a lot of us are just going to ruminate on that after the interview as well. So my next question is, it is no secret that men and women have different strengths. Some women find it hard to work with fellow female peers and even female seniors, such as female law firm partners. These women often say that it is easier to work with male peers and seniors instead, such as male law firm partners. Could you please share your advice for junior female lawyers especially, but also men, who are looking to understand female leadership styles and strengths, as well as to bridge their skills gaps in this regard?
I think this is a very interesting area. I always think that the leadership style doesn't really matter whether you're male or female. It's that it must be effective. And I think if you are leading, then you clearly have a team, and the styles that work best depend on the team. So you have to take on board that you will not always have a style when you start that suits the team that you've been landed with. And so one has to adjust. And I don't think there's any problem with that. As a female KC, I'm often involved in leading a team. I might have a male junior barrister, a female solicitor. It's really variable. And it never really occurs to me that it's not possible to build a collaborative style of working with them, which remains effective. So I will encourage them to speak freely. But if I'm finding that they are not contributing in a helpful way, I will speak with them, be they male or female. I think there are certain ways of doing that. I think it's necessary to have regard to, it's not so much politeness, but professional respect. Everybody that you're working with usually is a trained lawyer. And I think most critically, and I'm not sure everybody thinks about it in this way, but I definitely do, the client is paying for every lawyer on the team. And every lawyer on the team's brain is therefore needing to be engaged, because that is what the client is paying for. If you have people who are not contributing because they're either not understanding or they're afraid, or in very rare cases, they're just not engaged or not interested or even lazy, then that's an issue for the client in terms of what they are getting versus what they thought they were getting. And it's similarly the same if I have junior lawyers who never speak up. You know, it's that kind of, you really are here to add your brain's worth to the picture. And if you don't feel you can speak up, then I'm doing something wrong. But when you speak up, it has to be in a helpful, cooperative way. And there will be a time and a place for doing it, usually not when I'm perhaps on my feet in court or in a conference with the client, when we've already discussed and reached a strategy. Those kind of things and approaches whereby you call upon your junior member of your team is something I don't really see a difference in the way in which I deal with my juniors. One thing I have noticed, and I alluded to it earlier, is that I have literally never come across a male lawyer who starts his sentence with, "It may seem a silly question, but." And I can immediately think of at least 5 occasions when something like that has been the starting of a question from a female lawyer. And I'm almost at the point now where I smile, but I also sigh. You know, it's like, cut that first sentence off completely. It's not necessary. And all it does is signal that you doubt yourself. You want me to know that you doubt yourself. And it's as though you're trying to pull yourself down. It's not necessary. You know, if there is something you don't understand, ask it. And if I'm not able to answer it at the time, it will be about time management. It will not be that your question was a bad one. It will be that right now I can't address that question, but it's not an unimportant question and I will deal with it. And even if it's something that I can deal with very quickly because it's something that I understand, I want to know what you don't understand, if you see what I mean, so that I know I don't then leave something in your hands which you don't know what to do with. And I always say to my teams, if I give an instruction or I ask you to do something and you don't know what I mean, you don't know what I'm asking, don't waste even 15 minutes trying to piece it together. This is what I used to do. I look at an email or I try and remember exactly what had been said, or I would have scribbled down a note of what I was asked about. And I'd look at it and think, I have no idea what that actually translates to me doing now. I say, pick up the phone, just pick up the phone or send me an email and ask if you can speak with me to clarify what exactly I'm seeking. And that signals to me, not that you are in the wrong, not that you haven't understood because you don't get the point, certainly not that you're unintelligent. It tells me that whichever way I conveyed it, I didn't do a great job of my conveyance. And so I need to speak to you about it. And that way I can ensure that you remain an effective junior member of the team. So it's very collaborative. That's what I think female lawyers can do very, very well. I'm not saying that male lawyers can't. I'm just saying that it perhaps is not their immediate strategy.
That's honestly just very eye-opening. And I guess it's good to know that women are good at collaboration and can definitely use this strength when it comes to leading teams and, you know, helping clients
Indeed.
resolve their disputes.
Indeed.
Yeah, thank you. So this brings us to the audience Q&A round. If you have any questions for Sian, please submit it via the Q&A function on Zoom. So we have an audience question from an anonymous attendee, and he or she asks, how can I start my career in international arbitration?
Well, on this point, it's very necessary, I think, to join the relative organizations. There are very many of them. There are a huge number now of junior end organizations, and just go along. When I started in law, those organizations didn't really exist, the junior ones. And so I never really understood why juniors would go along to them, because I was in the middle of my career and heading towards being senior before they started to arise. They are hugely helpful. I mean, effectively take any opportunity to build your network amongst your peers. They are going to be the people that you are against, and the people who will get you instructions, and the people who will assist you in your future career. The sooner you get out there and start building that network, the better. And attending all the events that you can attend, not just for the CPD value, but also for the networking value. And you're all busy, you all want to have your own lives outside work. The critical thing about going to these is make the time work. So when you're there, introduce yourself, speak up, stand up, ask questions. If you go along to an event, a symposium, and prior to that, they ask you to prepare some questions and send them in. Don't just be one of the numbers sitting on the seats and not speaking out. Do the opposite. Just try it and see which one works better. I think you'll find that spending the time, standing up, asking questions means people speak to you because they immediately know that you're a person they've just effectively been introduced to, even though you haven't been introduced. I found that when I went to a symposium and put in questions and then realized I had to actually stand up and say the questions, although it was unexpected, I thought, actually, this is a brilliant way of ensuring that everybody who's in this room knows what I look like and knows what my name is, if you can remember to say your name, which you're meant to do at these things. And after that, it means people will come up to you and speak with you because you've said something that resonates. And it may even just be your experience on the case or your base where you're from, things like that. But these are all the starts of building a network. So just join the organizations and just attend.
That's very valuable advice. And I'm sure one that all of us junior lawyers will definitely follow in the future. So we have reached the end of our interview, and I would like to say thank you very much to Sian for her valuable time, insights, and generous sharing of experiences with us today. It has truly been a fascinating interview. To the members of the audience, thank you also for joining us, and please keep an eye out on our LinkedIn page for the next ArbChat session. Thank you again. Bye.
Thank you. Bye, Sunita.
Bye,
Really
Sian.
nice to see you.
Likewise, it was
Bye-bye.
lovely seeing you. Bye.